Can you hear us on Zoom? Can you hear us on Zoom?
Maybe you're muted.
What?
You're muted.
Might be. Oh, my computer's muted, but
This is mute.
oh, you can hear us. Okay.
Okay.
All right, well, I will go ahead and we can get started. Thank you all for joining us today in person and on Zoom. Today, we have the privilege of hearing from Ms. Ashley Baker about antitrust in big tech, and also with our Professor Woodcock from UK Law. Ashley Baker is the Director of Public Policy at the Committee for Justice. Her focus areas include the Supreme Court, technology and regulatory policy, and judicial nominations. Her writing has appeared in numerous national media outlets. She's also the founder of the recently formed Alliance on Antitrust Coalition. Ashley is an active member of the Federalist Society and a member of the Republican National Lawyers Association, where she has served as a speaker on the Supreme Court and the federal judiciary. Ashley also serves as an official observer on the Uniform Law Commission's drafting committee on the collection and use of personally identifiable data. As an expert on the judicial nomination process, Ashley has worked closely on recent Supreme Court justice confirmations. She also engages in policy analysis and outreach on legislation and regulations related to these issues by writing op-eds, letters to Congress for committee hearings, and regulatory comments to a broad array of executive agencies, including the FTC, NTIA, FCC, DOL, SEC, and DOJ Antitrust Division. And we will also be hearing from commentary from Professor Ramsey Woodcock. He's an assistant professor of law at the University of Kentucky, J. David Rosenberg College of Law, with a secondary appointment as an assistant professor of management at UK Gatton College of Business and Economics. He's an expert on antitrust law, economics, and policy, with a particular focus on the consequences of the information age toward the antitrust treatment of personalized pricing, dynamic pricing, and advertising. Please join me in welcoming both of our speakers today, starting with Ms. Ashley Baker.
Can everyone hear me okay? Like on screen too. Can you guys hear me? Yes, so okay. I've never had to talk or teach with one of these on, so like I promise I'm happy to be here and smiling. You just can't see it. First, quick question. So like, how many of you guys have taken antitrust? Okay, so like, oh, sorry, that was the question. 4 of you. Okay. So that's not that many. So I'm going to start with some historical background and kind of work our way forward a bit and talk to you about since I'm in the middle of things in DC, and you guys are fortunately not in the middle of things in DC. Talk a little bit about the political dynamics as well. So so I'd like to thank you, Mary and Fletcher, both for having me. This is definitely an exciting time to work on antitrust law. And it's an area of law that's been pretty well settled, so to speak, since around 1977. But recently, we've seen a lot of action in Congress and the court and in the state level as well, which is very important. So now I'm going to revisit some of the bigger questions that this epitomizes what is the role of antitrust in the economy and society. So not only does this debate present some interesting legal and economic questions, at the same time, today's antitrust debate underscores some interesting rifts and tensions between both political parties, and it serves somewhat as a microcosm of a broader political dynamic that's been the case with antitrust for Historically too, in the 1990s, you had Ralph Nader commenting on this too, that it was kind of a microcosm of broader politics that's made people care about antitrust. You see this going on right now too. And some of the questions right now that are freeing around big tech are really much broader questions about the role of government versus private power, and particularly in how and to what extent they should shape the market and the economy. That's the bigger issue. And today I'd like to discuss the recent proposals in the history of the law and how we got to where we are today, and the considerations specifically over tech. However, at first I'd like to take a moment to address the question that I hear most often. I've been doing these events about one per week or so for the past month or two, and there's this underlying question: is big tech too big? And I think that's really the wrong question to be asking. I mean, first to kind of start with the obvious, how big is too big? So at a basic level, bigness can be measured in users' evaluation. However, some things are more useful whenever there are more people using them. That's the economy of scale. So, for example, the first people to use the telephone or the first adapters of email or Tom from MySpace, they all found it more useful when more people were using it. I guess you guys are too young to remember Tom from MySpace. So I'm dating myself a bit there, but some things are better when people jump on the bandwagon, but that's not really the question that we're really asking here. And the more complex question is, what are the consequences of having laws that rely upon this arbitrary measure of bigness? We've seen Tim Wu was just appointed to the NEC, and he had this book, The Curse of Bigness. This oversimplifies it, but it does revolve around obviously that question of bigness, and that's something that the left kind of fixates on. But instead of asking the question, how big is too big, the relevant questions are really, does it harm consumers or otherwise violate competition law in acquiring and maintaining a monopoly, as the Supreme Court held in 1911 in the American tobacco cases? That's the question: acquiring and maintaining a monopoly, what behaviors they engage in, and exactly what problem we're trying to solve. The latter part's one that I stressed to Congress last week. I testified at a hearing in front of the Senate Committee on the Judiciary that was kind of a hearing to set off a series of more hearings, because Congress has a lot of hearings, for Klobuchar's bill that's pretty broad, I'll get to later. But the hearing was essentially about, what changes should we make to antitrust laws, like more broadly. This is kind of a big overview. And I think that last question of what problem we're trying to solve is just being completely ignored in this debate. And I mean, it's a very simple question. But it also gets to the heart of the historical debate of antitrust. It can yield like a wide variety of answers. So for decades, antitrust law was used with varying degrees of success as a proposed solution to dozens of different problems, many of which are completely unattached to the competitive process. However, a legal system is built upon laws that have specific intended outcomes that solve a specific problem. And the rule of law really requires that very basic foundation. Otherwise, the law is really unpredictable and unreliable, and essentially, after so many years, antitrust came to serve too many masters, and that was the status of antitrust in the 1960s, which brings us to the consumer welfare standard. So in the antitrust paradox, Robert Bork argued that Congress enacted the Sherman Act as a consumer welfare prescription, as they call it. So like in short, Section 1 of the Sherman Act prohibits activities that restrain trade if those restraints are unreasonably restrictive of competition in a relevant market. However, the actual language of the Sherman Act, Section 1, is every contract combination in the form of trust or otherwise or conspiracy in restraint of trade or commerce among several states or with foreign nations is declared to be illegal. Obviously, that's very broad. So really under that plain reading of the text, most things are illegal. Like shoes sold in pairs, for example. There are many historic examples. But courts for a very long time have recognized that not every restraint of trade can be illegal, because even a simple contract between two parties would technically restrain trade on some level. So this realization first occurred kind of not long after the Act's passage, and like during the era of 1890-ish and 1914. The courts really struggled with how exactly to apply antitrust law and what exactly the Sherman Act meant, what an unreasonable restraint of trade is, and that's something the courts really struggled with for the better half of the 20th century, and particularly the mid-20th century, leading up to the 1950s, 1960s, before the antitrust paradox, and then eventually in the 1970s, courts came to interpret the Sherman Act as applied to unreasonable restraints. And then in 1979, only a year after the Antitrust Paradox was published, the court explicitly acknowledged that the Sherman Act was enacted as a consumer welfare prescription. Sorry, it's really hard to talk. Please, this thing on. The consumer welfare standard, to kind of give you a bit of an overview of that. It uses economics to reliably predict when a conduct is likely to harm consumers as a result of harm to competition. So it's broad enough to incorporate a wide variety of evidence in shifting economic circumstances, but it's also clear and objective enough to not be subject to these beliefs that are not, of courts and forces that are not necessarily related to antitrust. So in doing so, it provides these sort of guardrails. And one, by the way, one misconception that I get asked about a lot about the consumer welfare standard is like, how does it apply to digital markets when it's only concerned about price? And that's actually not entirely true. So the consumer welfare standard is not concerned with price effects alone. It's has been concerned with things such as innovation, the competitive process, and that was actually the underpinning of the Microsoft case, was not price alone. But today, some of the proposals we have are kind of undermining the standard that has served us pretty well for the past 40 plus years. And that's not to say there aren't problems with the current state of antitrust law, but that standard has given us a lot of guideposts that are very helpful. So to give you kind of an overview of what's going on in DC and in the courts in Congress. So the House Judiciary Committee had this 16-month investigation, which at the end of which they produced like 451-page report that had all these recommendations. So this came out in October. The report had it had a lot of recommendations. So it called for Congress to override like 20-something Supreme Court precedents, which is pretty much all there is on antitrust. It overrode a Bull Review article. I keep pointing that out because it's just so absurd to ask Congress to clarify that Frank Easterbrook was wrong. Maybe all of you guys will one day write a law review article that's good enough that Congress will say, no, let's clarify that we deny about that person's views. I think that's quite funny, but it has a lot of other reforms that deal more procedurally with how antitrust cases are litigated, and a lot of other things. It was a huge, it was a huge undertaking. I'm not going to undermine or trivialize that aspect of it, but it really was so incredibly broad that it did not have any really specific target at the end. And then at the same time, we have a lot of lawsuits. Obviously, I'm sure you've heard about. We have the suit from the Department of Justice against Google. There's a kind of parallel state attorney general suit with that, and that's against Google. And then there's, let's see, 2 other coalitions of state agencies with suits that are also aimed at Google, one originating in Texas, one in Colorado. And then we have the FTC's case against Facebook about their acquisitions of Instagram and WhatsApp. That's led by the FTC, and then a larger coalition of state attorneys general led by New York, and that they actually motion for that to be dismissed recently. I'm not sure how that will hold up. I'm not going to go into really the specific details of some of those cases. I tend to not comment a ton on ongoing litigation, particularly when a lot of the documents are under seal like they are in these cases, particularly the Texas case. I think there are a lot of unknowns there. So I'm a little bit reluctant to really get into the details of that litigation, but that is an important part of the dynamic between courts, Congress, and everything else that I think is important to consider. And then more recently, we have Senator Klobuchar's bill, which incorporates a lot of the recommendations from the House report. So the Senator Klobuchar's bill is called the Competition and Antitrust Law Enforcement Act of 2021. But that's really not, it's really not about just giving stronger tools for enforcement. And by the way, I'm in favor of enforcing antitrust laws that are on the books. And I'll get into some positive recommendations later to reform it, things such as eliminating exemptions. But this really is about making antitrust law, reforming it so that it protects competitors and not the competitive process and consumers. And that's a big difference between antitrust law in the United States and the European Union, for example. One major difference is that in the US, we don't protect competitors from competition. We protect consumers and competition as a whole. We hold the spirit. Whereas in the European Union, it does, this is again oversimplified a bit, does protect competitors. If you don't notice, I mean, most of the large companies are in the United States. For better or worse, we might not like some of the things they do, but they are based here, and that's a product of the regulatory system beyond antitrust too. Privacy, European privacy, but there are a lot of things that have drained venture capital investments out of Europe, which is a secondary issue. But back to the Klobuchar bill. So it would prohibit businesses and practices that harm competitors, and the legal standards that define exclusionary conduct as conduct that would materially disadvantages or tends to foreclose or limit the ability or incentive of one or more actual or potential competitors, rather than, like I said, harm to competition in a relevant market. So it also has a provision that I think is actually overlooked. I talk a lot about antitrust and intellectual property. It says that it explicitly excludes applying or enforcing a patent, trademark, or copyright alone from constituting exclusionary conduct unless baseless or in bad faith. However, these activities may be considered as part of a course of conduct that does establish exclusionary conduct. So there's not really much of a difference there. I think that's particularly chilling for those who would like to pursue intellectual property rights or patents or standard essential patents, which is another kind of fun issue in antitrust is SEPs. It also shifts the laws to this sort of risk-based framework. So rather than proposing the mergers that present actual harms to the consumers or the competitive process, would add a risk-based standard to the foundational antitrust law. So it does so by amending the Clayton Act to prohibit exclusionary conduct that presents an appreciable risk of harming competition. So what exactly is appreciable risk? We're not entirely sure. It's kind of, I've jokingly called this Amy Klobuchar's, I know it when I see it, theory of antitrust, because that's kind of what the appreciable risk standard would amount to. And then with mergers, it does shift the burden of proof for dominant firms and proving that mergers would not be an appreciable lessening or materially lessening competition. So the burden shifting proposal is actually a big one, I think. So in most areas of law, the burden of proof, the evidentiary burden of proof is on the government or the plaintiff or the person bringing a suit. That's not always the case in antitrust. There are a lot of exceptions there that I won't get into, but this would shift it onto the companies. And my biggest problem with this is that it's based on bad rationale. It's kind of based on the rationale that the FTC or DOJ are having problems winning the cases that they do bring at least. And their win rate is really incredible. I mean, no one is having problems. The government's not having any problems winning cases. And it would require the companies to use a pro-efficiency defense, which only like in one litigated case ever have they prevailed on. And the FTC, I think, is the only, FTC and DOJ have only lost, I think, 4 or 5 mergers cases in the last 8 years. So like their win rate is pretty high. Whether or not they're bringing the most challenging cases is another point of debate. But I mean, that can be solved by something other than shifting the burden of proof. That can be solved by more agency funding. That can be solved by streamlining a lot of procedural things. So I think that's particularly damaging. So speaking of which, meanwhile, there's a lot of underlying issues involving the agency authority. As you probably know, both the DOJ Antitrust Division and the FTC have authority over antitrust law, antitrust enforcement, and that's created a lot of problems. Not just there's one, the efficiency of it. We could do a lot better in making that process a lot more efficient, but also delineating which one is in charge of monitoring which industry. You had a case that FTC versus Qualcomm, which the Ninth Circuit decided in August, where you had actually the FTC and the DOJ on opposite sides, which is not very productive. And there were a lot of problems with that case. The bigger mark of it was that the DOJ was on the opposite side of that. That's actually one that I think they're, if the FTC decides to file a cert petition, I think that's due like March 20th or something to the Supreme Court. So that's one thing to have on your radar. I don't think I would say that it would be unwise if they did, but that's never stopped the FTC litigators before. So that was one issue. Mike Lee has something out called the One Agency Act, which consolidate that authority under the Department of Justice. I never thought it's necessarily necessary to put it all under one agency. There are multiple ways to kind of go about making this more efficient, but it would make sense if you were going to pick one or the other for it to be the DOJ. They can represent the views of the United States. They have certain criminal enforcement authority that the FTC doesn't necessarily have. I think that makes a lot of sense. I think it's a good starting point for that. And there are also, like I said, I'm not arguing 100% for the status quo. Maybe 90%, I'll give you that. But I think that there are reforms we can make to, like I said, clarify agency authority, process-related reforms, standardizing procedures, also merger like notification procedures, having some sort of underlying standards. We're going to have it split between two agencies. I think there should be some clear standards. There are also antitrust exemptions that I think should not exist, such as exemptions for nonprofits and common carriers. There's also the state action doctrine. Essentially, the government is not held to the same standard for violating antitrust law, and arguably they're the biggest monopolist. We see that playing out, like state licensing boards, for example, is one big area that people are talking about for antitrust reform there. And there's also the direct purchaser rule, which is something that could be. There are two decisions that Congress could override to give consumers better standing when suing, for example, Apple for violations in the App Store. So those are some kind of positive agenda items that I think are worth supporting. That's kind of the history of all the pieces that are in this debate. So, but like I said, kind of getting back to that basic question, it's important to look at like what problem we're trying to solve. And you see there's a lot of momentum right now because people on the right want to use antitrust because there are problems with speech online, which I think those are legitimate problems. Antitrust is not the right tool. Privacy concerns, I actually support a federal baseline privacy bill. But antitrust is not really the tool for that. And then on the left, you have those who are just concerned about corporate power, how big the companies are, and essentially want to, a roundabout way to ensure redistribution of wealth is essentially what they're kind of doing to fight equality. So if you have these two very, very different goals, but kind of somewhat the same solution or kind of compromising on it, I don't see that really working out too well in the long run. I don't see that working out really well for conservatives particularly. I mean, that might give us one kind of heads against these tech companies, but in the long run, I mean, conservatives aren't really the best at weaponizing litigation and using the bureaucracy to their effect. That kind of goes against what we stand for, and the other side has decades of experience doing that. So we're not exactly very good at it. So from a purely practical standpoint, this is strategically suicidal, I think. And like I said, we've had the standard in place for a long time, consumer welfare standard. I think there's a lot of misinformation surrounding that, and partially we don't do a great job of explaining what it is. Those of us who support it. So I think adding some clarity to that debate is really necessary. And there are ways in which, the Klobuchar's bill, for example, undermines the consumer welfare standard not being statutory. It's a broader set of principles. It's not as if it's going to be overturned with one bill. And that's one point of misconception also about the role of the courts and deciding antitrust cases. A lot of people, particularly on the right, don't really understand the difference between judge-made law and the sort of way that antitrust has had to develop as essentially a common law type of, in a sort of common law way through judicial interpretations and like judicial activism or judge-made law in like the pejorative sense. So these two things aren't like mutually exclusive. So I mean, you can have judicial activism where judges really calling the calling the shots and being arbitrator, but the consumer welfare standard is something that has helped guard against that over the years. So I think in the end there, I could talk about this for an hour or two, especially getting back to kind of the basics starting in 1890. But I'm going to give Ramsey some time to speak, and also I want to spend some time with Q&A as well. Sorry to talk this long too. Ramsey, I think you're on mute.
Okay. Great. Is there some feedback, or can you hear me okay?
Mm-hmm.
Okay. Great. Well, so thanks for this fantastic, I think, overview of where we are with antitrust today. Although I come from politically a different side of the field, antitrust is in a peculiar moment right now, such that I actually find very little that I can take issue with in what Ashley has said. So I will mostly try to sort of provide the same story, maybe from a little bit more of a kind of left-wing perspective, and try to highlight the ways in which actually, I think there's a lot in common between the current conservative position on antitrust that Ashley's articulating, and I think what a kind of true progressive position ought to be at the moment too. So to provide a little bit of background, I think what you see in the resurgence of interest in antitrust on the left is three sort of strands that are meeting. One is this sort of frustration with Citizens United and a kind of pervasive sense that there's too much money in politics, and particularly too much conservative money in politics. And that's been sort of percolating on the left for quite a while now. And then there's a sort of pervasive frustration with the inability to achieve redistribution of wealth through the tax system. So instead of marginal tax rates increasing over the last couple of generations, they've been falling, and so progressives are very frustrated about that and looking for a way to achieve a wealth redistribution through alternative means to the tax system. And but those two, I think, weren't sufficient to lead to the current resurgence. There was a third element that was necessary that really provided the spark, and that is the press. So the rise of the tech giants has virtually wiped out the principal source of revenue that the press had relied on for 100 years, which is advertising revenue. And so the press has been a kind of competitive victim of the tech giants, and they're understandably very upset about it, and have been looking for ways to strike back. And advocating antitrust enforcement, more vigorous antitrust enforcement, has been a way that the press has found to do that. So, over the last 5 years in particular, the press, certainly on the left, has been entirely anti-big tech, right? The sort of tech lash has very much been driven by, major newspaper reporting that's been very, very negative about the tech giants. And the press sees a sort of broader antitrust campaign as a way of making allies for its own particular campaign to give itself some sort of competitive privilege by getting antitrust enforcers to smash their competitive adversaries in the advertising market. And so they very much promoted a kind of broad-based resurgence of interest. And certainly I can't point to any specific studies showing a sort of bias in favor of antitrust or against the tech giants, but the connection between the press and, for example, the House report that Ashley has been telling you about is absolutely clear, right? The leader of that committee, David Cicilline, is a major advocate of legislation sponsored by the News Media Alliance, which is the newspaper industry's main lobbying organization, that would actually give newspapers an antitrust exemption to allow them to form a cartel to negotiate against the tech giants. So, the sort of connection here between the press's own interest in using antitrust to defend its competitive position and the resurgence of interest in antitrust, I think, is fairly obvious. So we've got this sort of, and it's appealed to progressives more generally because they've been looking for a way around their inability to redistribute through the tax system, and antitrust seems like a way to do it. These big companies make a lot of money. Their CEOs make millions, hundreds of millions of dollars. We can maybe move the dial a bit in redistributing wealth by smashing all the big companies. That's the logic. And then finally, this idea of getting preventing big corporations from having too much influence over politics. Well, how do you do that? Again, if there's no more big corporations out there, then we don't have to worry about Citizens United and so on. So these three things have come together and created a kind of progressive obsession over the last few years about antitrust. But I think, first of all, that it's going to be lessening in the coming years, if only because now the inability to get redistribution of wealth through the tax system seems to be going away. We've had a number of massive stimulus bills, most recent one in particular, only sort of about COVID in name only, but really much more obviously about trying to implement longer term redistributive programs. And that suggests, I mean, when the government is sending checks to millions of Americans, that's tax and transfer in action. And so as this becomes more politically feasible, I think the kind of pressure valve is going to be let open, and there's going to just be less interest in using the antitrust laws to try to achieve these results. And the same thing is going to go for the sort of Citizens United idea, to the extent that progressives are able to be, politically successful in implementing their projects through tax and transfer. They're not worried anymore that there's too much corporate influence over, over government. And indeed, corporations themselves seem to have become more progressive in recent years. And so there's going to be less of a pervasive sense that we have to do something about them by smashing them. So I think politically, we're going to see this tail off. But the question is it going to tail off before serious damage is done to the antitrust laws? That's not completely evident. So I agree with Ashley that at the end of the day, the antitrust laws, they're really not about the redistribution of wealth, and they're not even about bigness. The reason why we have an industrial economy is because we're okay with bigness, right? By definition, industrialization means firms that are able to produce a lot in one place, and that's bigness. That's what mass production is. So there's nothing inherent. If you're on a progressive side, you shouldn't have any inherent problem with bigness. If anything, the wealth that you want to redistribute is due to the presence of bigness. And so we want to make sure that the antitrust laws don't smash the big firms that are responsible for the plenty that we're trying to redistribute in the first place. And I certainly think that moving off of the consumer welfare standard could put us in that position. The consumer welfare standard is ultimately, the test that it imposes is to see whether or not breaking up a firm will actually lead to more production, more innovation, higher output or not. And if we know that in general, there's a connection between size and more output and more innovation, and there generally is one, then we don't want to smash away without being very, very careful about what we're doing. We need that consumer welfare test. So I think some of the proposals that Ashley mentioned are probably okay, the ones that don't really implicate the consumer welfare standard. So the idea that maybe we should shift the burdens in merger reviews is not an inherently anti-consumer welfare standard. All it's saying is that the party that that needs to prove compliance with the standard should be the party that's it should be the other party in the case. And that could be productive, because there is actually quite a bit of scholarship out there showing that over the last generation, mergers that have been approved have ended up leading to higher prices. Now, some of that might be because they were producing better products. So we can't say for sure that in all those cases, the higher prices were a problem. If we need to pay more for better products, that's better than not having the better products at all. But it seems reasonable to suppose that we haven't been doing enough merger enforcement. And so as far as a compromise, it strikes me that that sort of burden shifting probably is not such a big is not such a big threat. But there have been other proposals, such as rules against self-preferencing by platforms like Amazon, that I think really are a potential problem. So in order to have a business function, it has to be able to control multiple levels of the supply chain. You can't produce without controlling multiple levels of the supply chain. You produce a pencil, what are you doing? You're controlling the part of the supply chain that creates the wood and the part of the supply chain that creates the graphite and the part of the supply chain that puts them together. That's how you get a pencil. So rules against self-preferencing are basically saying you have to vertically disintegrate at every level. Amazon can't both run an e-commerce platform and also sell products on its own platform. That's saying Amazon has to vertically deintegrate, can only be an e-commerce platform, it can't also be a retailer. And that's a very serious problem, because to make products, you bring different levels of the supply chain together. In order for Amazon to offer a great product, it needs to have control over both the kinds of products that are sold on its platform and the platform itself. And so rules against self-preferencing they're logically incoherent, and they could do a lot of damage. And I think that we need to be very careful about them. My sense, I don't want to take too much time, my sense to close is that some of the pressure, the political pressure here, is going to be released over the next few years, but we have to really fight to make sure in the meantime that these reform efforts, however well-intentioned, don't end up seriously wrecking our industrial, or the industrial organization we have in this country at the moment.
Do you need to follow up on that for like 1 or 2 minutes?
Sure.
Yeah, sure. Just to follow up on those points. I mean, I agree with most of what Ramsey said. One point where I don't agree is that that pressure on the left over antitrust will kind of dissipate that quickly. I think journalists have a big incentive to kind of keep this debate going. That works in their favor, and most of our journalists are left leaning, and I don't see the press versus big tech battle going on ending really anytime soon. So I think to that extent it will kind of drag out, that these reporters will kind of keep pushing it. And I think with the Klobuchar, I mean, when I testified, for example, in front of the Judiciary Committee, those on the left in the panel, they are very serious about doing something. They unlike the House, which their hearings have been kind of a bit more show than anything, the Senate, which actually has some of the proposals, and the Klobuchar bill, for example, I mean, she's very serious about getting something done. I don't agree with her specific proposal, but I do appreciate the fact that they were conducting kind of a serious hearing, a serious inquiry, because some of the stuff, to be quite frank, like in the House, it's been anytime you invite CEOs to testify, you're just not going to have a productive hearing. It doesn't really help as much as anything. It's a media circus. And I think it's also another problem with these proposals that kind of get to the heart of how we litigate the cases is we just had this story of litigation against these companies, and then you have Congress swooping in to immediately say, let's change all the rules. So I think that does a lot of harm, and kind of the independence of the judiciary, and the message that sends is that they don't trust the courts to make the right decision. And that's why I'm immediately skeptical of anyone who says, oh, well, the first thing we need to do is to take the power out of the hands of the judiciary, which is problematic in a lot of ways. First of all, because that is how antitrust law has developed over the years, because Congress intended that, but also that does put it in the hands of bureaucrats and politicians, and that makes the process inherently a lot more political and more likely to serve all these different objectives that are not the welfare of consumers. In terms of the burden shifting proposals, I would say my objection to that is more of a fundamental one in terms of who should generally bear the burden of proof. And it's not that companies don't bear the burden of proof already, and a good percentage of this case is the case of the National Bank. That standard does already shift the burden in a lot of cases. But I think overall, I mean, I was making fun of the House Judiciary Committee for having that like footnote in their report that says, let's clarify like what Frank Easterbrook's article meant and what its influence on Congress has been. But that's really about the error cost framework and how having one case that's potentially wrong to break up a company that could have helped consumers a lot in the long run, that's a lot more dangerous than maybe letting one merger that may or may not be anti-competitive. I think I agree with Easterbrook there that that's a lot more harmful overall. And regarding Citizens United, I think Ramsey's right that there's definitely the who are corporations influencing part of it, but I think that's also kind of a red herring too, and that's most corporations fund mostly left-leaning groups. Most of their support does not go to right-leaning groups. They're also, beyond just giving grants to nonprofits or whatever other support, or PACs and candidates, whatever support they give. And there's also things such as like side price settlements, which is something that's very few people look into, and all these other kind of backdoor ways of funding left-wing organizations. And that money rarely goes to the groups on the right. And that's because the employees of these companies have become so left-leaning that they will, at this point, kind of revolt. I've said this before, is, I think one of the worst management decisions from just a purely business perspective that like Google is making. You can't let your employees turn into a band of activists for a certain cause. It's not going to turn out that well. And I think actually that's kind of undermining them more than any, unless, antitrust law does break them up. I think that's, they're actually kind of likely to, I would say, self-destruct. But every time, they turn down a government contract, there's some mid-sized company saying, look, there's an opportunity. So I think what we see right now is kind of the competitive process working out itself too in some of these underlying political dynamics.
Actually, if I may interject, I think that's one of the, one of the oddest things about this whole antitrust episode is the way you've seen, progressives advocating vociferously for the destruction of these incredibly progressive companies, right? I mean, you've got progressives saying let's smash Google, which is one of the biggest progressive donors out there, and not sort of understanding the irony of the fact that they got the Trump administration to actually file the case, right? So there's certainly been a very, this antitrust has made for very strange bedfellows over the last year or so.
Yeah, I saw someone tweeted the other day that it's actually pretty amazing how Rupert Murdoch managed to get the American left on his side and mobilizing against, for a fight in Australia, and being, and a conservative located in Australia. But the news versus tech fight is one that I don't think is necessarily inherently an antitrust problem. And like I said, some of these exemptions make no sense, and I'm in favor of enforcing the law. But yeah, the political dynamics are really interesting. You see definitely some rifts amongst the right. I was telling someone last night, actually, there's kind of a rift on the right too, and this is really relevant to federal society as a whole. I guess there's kind of this idea of this common good originalism, which I don't think is common or good or originalism, but it's I think more of a conservative judicial activist stance. And there's a direct overlap between those who believe in that and those who want to use antitrust for populist means to weaponize the law. It's not coincidental that rift and the conservative legal movements exactly directly overlaps. And it's like, these are their two issues.
Yeah, and actually, I think, as a progressive myself, I'm very critical of this sort of antitrust movement on the left. And one of the reasons is because I actually think it's not all that radical, right? And that explains, in some sense, its appeal on the right. So, what's the end result of, more antitrust enforcement? It's lots of perfectly competitive markets everywhere, right? And so, for a progressive, the whole foundation of progressivism in a way is a rejection of the idea that we can just leave it to markets, perfectly competitive markets, to achieve the kind of just distributive outcomes that we want, right? It's the idea that even at competitive prices, wealth is not distributed fairly. So my critique of the left in this is that they've lost sight of, they seem to have forgotten that the market is not their friend. But the flip side is that explains, I think, to a certain extent, the appeal of the antitrust movement on the right, which is, it is ultimately, I mean, at the end of the day, antitrust is fundamentally about markets. Let's have markets everywhere. Let's just make sure that they're absolutely free markets. And so I think that explains some of the interest on the other side of this thing.
I think on the right, though, there's more of an open rejection of free market economics from that camp. I think it's really more retaliatory than anything, because of some of these things that these companies have done, which I don't like either. But constant moderation decisions are not antitrust decisions. Well, usually they're not antitrust decisions. But I view it as kind of more retaliatory, and I see that faction as kind of rebelling against the market. But I do see, I'd be curious your thoughts. I do see the more progressive side of the left that's in favor of antitrust populism. They're drifting like much further left, so to speak, than they were. I did one of these events with Professor Robert Bork, for example, who believes in the consumer welfare standard, was there, at its very inception, was one of the original scholars, as kind of moderately left leaning, and he was saying the same thing, is that you had these divisions on the left and the right, and they somewhat mirror each other.
Yeah, no, I think that's right. I mean, Hovenkamp is, to my mind, the sort of classic moderate, right? I mean, he really is, he's a proud, moderate centrist in these debates. But yeah, I mean, I don't think that there's really any intellectual coherence at all to the sort of progressive antitrust populism that we're seeing. And the where to look for that, to really understand what's going on there, I think, is there's a Washington Monthly article by Phil Longman, who's one of the Open Markets Institute people, and it's called something like it's an article that calls for allowing small business collusion. And he comes out and he says, what we want, it's not really about antitrust at all. We want the small businesses to be able to collude to raise prices, and then we want to smash the big businesses. And the idea is that way we'll redistribute wealth. The small businesses presumably are owned by poorer folk, and so they'll be able to charge higher prices and get more money. And the rich businesses are owned, the big businesses are owned by the rich. We'll smash them and they'll get poorer. And I think that it's extraordinary that this is articulated this way, because it's so completely like medieval, right? It's the way we figured out a better way to redistribute wealth. It's called tax and transfer. And the reason why it's better is because we don't have to smash productive organizations to do it. We can just take the surpluses they generate and give them to the people we want to have them get it. But their idea is it's built on this incredible frustration with not being able to use tax and transfer to do that. And it's just saying, okay, let's radically reorganize the industrial structure in the United States to achieve particular redistributive ends. And so that's an extreme radicalism, and it's not coherent in an antitrust sense. It's not about, let's find the big firms that are, harming competition and, leading to inefficiencies or harming consumers and do something about it. It's purely, let's reorganize American industry to achieve a single goal, which is redistribution of wealth. So that is very, very radical, I'd agree, and not plugged in at all intellectually to any of the debates we've been having over antitrust over the last 4 years. It's not about how do you identify the big firm that's actually doing harm or not in any sense. So there's that radicalism. But from my perspective, there's also a lack of radicalism, which is, tax and transfer is a much more effective way of redistributing wealth. And so if the problem here is simply that progressives can't bring together the political majorities to get tax and transfer to happen, the solution is maybe to make the case for tax and transfer better rather than trying to sort of smash industry. But as I said, my sense though is that, and I agree, in the near term, you're right, this is going to still play out over the next 5 years. But in the next 10 years or next 15 years, I really do think, assuming that the political winds have shifted towards more redistribution, and I think they have, I think we'll see some of the pressure come off doing this in antitrust.
Yeah, while I probably completely disagree with you about tax and transfer, I do think that's a legitimate way of going about doing that, as opposed to antitrust. I think some of the like Open Markets Institute, they're kind of saying the quiet parts out loud now. And a lot of the stuff, when I testified last week, it was also with the president of Open Markets Institute. I was sad I did not get a chance to speak at the very end, because I sat there and I wrote down every single thing that he should use, and he said that antitrust should be used for. And I was going to say, he made the best case for the consumer welfare standard that I've ever heard, because he wanted to use it for 37 different things and democracy 12 times, apparently. And that's, a broad array of different purposes for antitrust. And no law should serve that many purposes. I think we should probably open up the questions now.
Yeah, we probably have time for one quick question, and then
oh, sorry.
No, it's okay. That was great. You want to have a question?
you.
Do we not have a question or?
No question.
What?
No questions.
No questions. Well then I've got a comment then if we still have a couple of minutes.
Sure.
Well, you know, on this issue of you know, what to do with the two enforcement agencies, you know, I think, you know, I agree that there should be consolidation, but I think we should consolidate in the FTC and not in the Department of Justice. And I think that that's really where, and it's interestingly, there's been progressive scholarship calling for consolidation as well. And I think that's the dividing line politically, is the FTC is, I think, properly viewed as the more sort of progressive of the two enforcers. And so if we're going to bring consolidation, I'd like to see it in the agency that was really created for the purpose of enforcing the antitrust laws, rather than consolidating in the Department of Justice.
I'm sympathetic to the argument that FTC does have some more in-house expertise as a result of it being kind of created in the way that it can still, enforce under Section 5 of the FTC Act. And then I think there are certain things, particularly representing the United States in cases like fraud. I use the Qualcomm case a lot to kind of minimize this, where the view of the United States government, particularly in court, is the DOJ. And like I said, I don't think that it has to be one agency or the other, but I do see a lot of validity in that for being DOJ. And I also find it kind of funny that I've seen some people argue that the FTC is less susceptible to politicization, which is pretty telling me that's very much not the case. Really, in the 1970s.
Yeah. Well, thank you very much. I've really enjoyed this opportunity, and sorry I couldn't be there in person with you.
Thank you, Professor. You can see us from all the way back there. Thank you.